In this dramatic courtroom showdown, a self-represented defendant attempts to take on the legal system using sovereign citizen-style arguments, but the outcome doesn't go the way he expects. Facing charges that include contempt of court and unpaid fines, he insists the trial is unfair because he's only had an hour and a half to study the law, while the prosecutor has years of legal education. He files motions to dismiss the case, claiming violations of his rights and demanding the charges be thrown out. The judge, however, calmly reminds him that he previously refused a court-appointed lawyer and chose to represent himself. She points out his repeated failures to appear in court and his history of ignoring fines and deadlines. One by one, his motions are denied as the court makes it clear that misunderstanding the law is not a legal defense. As the hearing continues, the tension rises. The judge ultimately sentences him to 45 days in jail for failing to appear and failing to pay fines, giving him credit for time already served. A new trial date is set, and his bond remains in place due to his record of not showing up. Before concluding, the judge advises him that he can still apply for a court-appointed attorney and suggests that seeking real legal help would be far more effective than repeating flawed legal theories. It's a powerful and eye-opening reminder that courtroom arguments require more than confidence, they require real legal knowledge.
7ST 226707ST and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th. While he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the two files he has to that offer or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the two open charges, Mr. Martinez, and you're proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the two files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or an adequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read.
All right, go right ahead.
For every waste of time and the money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial, and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions, making sure my rights were protected. And Rules 4.3, if they know the law and what I'm saying, these are U.S. Supreme Court, Michigan rules, and carriage, also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then, he doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial. There's a federal law and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that. And you didn't want that either. So then we went through the hearings and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you wish.
Bogus information. You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. 435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new trial along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you.
This courtroom hearing starts with tension already in the air. A self-represented defendant stands before the judge, determined to challenge the system on his own terms. He's facing serious issues, contempt of court, unpaid fines, and a history of failing to appear. But instead of focusing on resolving the charges, he chooses a different path. He decides to argue that the system itself is unfair. From the very beginning, he insists he hasn't been given a fair opportunity to defend himself. He claims he's only had an hour and a half to study the law, while the prosecutor has years of formal education and courtroom experience. According to him, that imbalance alone makes the proceedings unjust. He argues that how can anyone expect him to compete with trained attorneys when he barely has time to research statutes and legal procedures. He speaks confidently, but there's a disconnect between his confidence and the substance of his arguments. He files motions to dismiss all charges, citing the Speedy Trial Act and claiming violations of his constitutional rights. He suggests that his rights have been infringed upon, that the court has not respected proper procedure, and that the case should simply be thrown out. The judge listens patiently. She doesn't interrupt unnecessarily. She allows him to speak, to present his reasoning, to place his objections on the record. But when it's her turn to respond, her tone is calm, controlled, and firm. She reminds him that the right to counsel was offered to him. Not once, but multiple times. He made a clear decision to refuse a court-appointed attorney. He chose to represent himself. Now, standing in court and arguing that he lacks legal knowledge, he faces the reality of that choice. The judge points out that the legal system cannot force someone to accept representation if they knowingly waive that right. Self-representation comes with responsibility. It does not come with special treatment. As the hearing continues, the court reviews his history. There are multiple failures to appear. Deadlines were missed. Fines went unpaid. Opportunities to resolve the case earlier were given. Plea offers were extended. Each time, he either ignored the process or declined to cooperate. He attempts to pivot back to his rights. He repeats phrases about fairness and equality under the law. He insists that the prosecution has an unfair advantage. But the judge explains something fundamental. Fairness in court does not mean equal experience. It means equal opportunity under the law. He was given the opportunity to hire a lawyer. He was given the opportunity to request a court-appointed attorney. He declined. The courtroom dynamic shifts when the judge addresses his motion to dismiss. She explains that the Speedy Trial Act does not apply in the way he believes it does. She clarifies the timelines. She references the procedural history of the case. The delays, she notes, are largely attributable to his own actions, his failures to appear, his decisions, his requests. Each motion is denied, one by one. There's a visible frustration building. He attempts to argue technicalities, stumbling over legal terminology. At moments, he reads from papers in front of him, struggling with phrasing and pronunciation. The confidence he had at the start begins to crack under the weight of structured judicial reasoning. The judge remains steady. She does not mock him. She does not raise her voice. But she does not entertain arguments that have no legal foundation. She emphasizes that courts operate on established statutes, case law, and procedural rules, not on internet interpretations or misunderstood legal theories. Then comes sentencing. The judge turns her attention to the failures to appear and unpaid fines. She explains that ignoring court orders has consequences. A courtroom is not a place where attendance is optional. When someone repeatedly fails to show up, it disrupts the administration of justice. She imposes 45 days in jail. There is credit for 23 days already served. The sentence will run concurrently. A new trial date is set for the remaining matters. Because of his history of non-appearance, the bond remains in place. The court cannot simply assume he will return voluntarily. There's a pause as the weight of the sentence settles in. But the judge doesn't stop there. She offers practical advice. She explains that he still has the right to request a court-appointed lawyer through the appropriate Indigent Defense Commission. If he cannot afford counsel, there is a system designed to assist him. She suggests that instead of spending time arguing procedural misunderstandings, he might consider applying for representation. She also mentions that while in custody, legal research materials are managed by the sheriff's department. If he wishes to study the law further, those resources exist, but they are not a substitute for professional legal training. The contrast in the courtroom is striking. On one side, a defendant relying on self-taught interpretations of the law. On the other, a judge grounded in years of legal practice, applying statutes and precedent methodically. What becomes clear throughout the hearing is that the court is not reacting emotionally. It is reacting procedurally. Every decision is tied to documented history. Every denial is supported by reasoning. Every consequence stems from actions already taken. There is an important lesson unfolding in real time. The right to represent oneself is protected. But that right does not shield someone from the consequences of misunderstanding the law. Courts do not lower legal standards because someone declines representation. As the hearing wraps up, the defendant's earlier arguments about unfairness seem overshadowed by a more immediate reality: choices matter. Refusing counsel matters. Missing court dates matters. Ignoring fines matters. The system gave him options. He exercised his autonomy. And now, the system is responding within its authority. This courtroom exchange serves as a powerful reminder of how legal proceedings actually function. It's not about dramatic speeches or bold claims. It's about documentation, procedure, and accountability. When someone attempts to challenge that structure without preparation or legal grounding, the results can be swift and sobering. In the end, the judge's message is simple and clear. If you want to fight charges effectively, use the tools available to you. Request counsel. Understand the law through legitimate channels. Participate in the process. Because in a real courtroom, arguments must stand on more than confidence, they must stand on law.